There's one very famous Canadian decision about the rule of law. It's called Roncarelli versus Duplessis. This took place in Quebec during the 1950s when Premier Maurice Duplessis took a very strong dislike to a restaurant owner by the last name was Roncarelli. That was his last name. He was a Jehovah's Witness. And the Jehovah's Witnesses in Quebec in the 1950s were getting into trouble for distributing their literature. And so there's all these laws, which were eventually struck down by the Supreme Court of Canada, that were targeting the Jehovah's Witnesses. And very popular laws. These people were not well liked in Catholic Quebec in the 1950s, handing out their tracts, saying that the Catholic Church was not the true faith and you should become a Jehovah's Witness. Very offensive. And so the repression of Jehovah's Witnesses was very popular. Now, what happened there was interesting. The premier phoned the head of the commission that grants liquor licenses and politely asked him to pull the liquor license of Mr. Roncarelli's restaurant. And so the police barged in one day and shut down the restaurant and said, you don't have a liquor license and you're serving, wine with lunch. They did that to punish Mr. Roncarelli for what he was doing was posting bail. And he was a wealthy guy, somewhat wealthy, had some means. And so the Jehovah's Witnesses would get arrested under laws that were later struck down for distributing their unpopular literature on street corners. And then he would post bail for the Jehovah's Witnesses so that they could get out of jail and be free pending the trial. So a court action was launched, and the Supreme Court of Canada said in no uncertain terms that this was a violation of the rule of law, that the Premier of Quebec would order the liquor commissioner to pull the liquor license of this restaurant owner for political purposes. And the Premier's argument was, well, the legislation says that the Liquor Control Board, whatever the body was, it was a government body, says they may, in their discretion, they can grant or deny licenses. So, hey, nothing to get upset about here, because the law says they've got the legal right, they've got that discretion to grant the liquor license or pull it. But the Supreme Court ruled that the discretion has to be exercised according to law and according to proper principles. So it would not be proper for the Liquor Control Board to deny a liquor license to somebody because they disliked the color of his hair.